So thanks for joining today's session on Wheels and Wings, Law, Regulation, and Mass Mobility in the 20th Century with Eva Vaillancourt and Joanna Grisinger. So I'll introduce each of the speakers in order. So Eva will be speaking first. She's a PhD student in history at UC Berkeley. Her work explores how communities enforce norms and create order in the social, political, institutional, and epistemological senses. Her dissertation explores these questions through the history of road traffic rules, red lights, white lines, stop signs, speed limits, pedestrian crosswalks, the requirement to signal before turning, and all the other criminally enforceable instructions we obey and disobey every time we step into the street. Her work connects changing philosophies of order to lived practices on the street, and shows that so far as traffic is concerned, the triumph of modern rationalization was nowhere near as complete as we might think. And Eva is the winner of this year's Austin Serret Award for the best graduate student paper at the LCH conference. And she'll be speaking today on the birth of the British crosswalk, mystical lines, mechanical obedience, and the puzzle of law as infrastructure. Please take it away.
Thank you so much, Simon. Can everyone hear me okay? Great. I really appreciate this opportunity. This is a two-part talk. I'm going to try and kind of zoom a bit through the political context and get to the legal stuff. I'm very insecure about my legal knowledge, so I would invite you to tell me if anything, what you guys think, if anything's wrong, if I need to learn any, explore other things, and all that. Okay, so let me share the screen here. Can everyone see that? Okay, so I don't know if you guys had ever saw things like this on your campus. These were called Kiwi bots. They started appearing a couple years ago on UC Berkeley's campuses, and they were on UC Berkeley campus, and they were used to deliver takeout. They're autonomous vehicles. They use GPS, lasers, maps, and machine learning to navigate the campus's roads and footpaths. But one thing they had enormous difficulty with is crosswalks. They were constantly getting stuck, as you see here, trying to decide when they should start crossing. The bot's maps told it that the vehicles were supposed to yield here, but its obstacle detection system saw the oncoming cars and told it to wait. Drivers, for their part, didn't know or didn't care that the robot was trying to invoke a legal rule. Navigating a crosswalk, as it turns out, involves a lot more than just probabilistically forecasting how bodies are going to move in space. It's a complex socio-legal interaction in which two people use eye contact and spatial positioning to signal to one another whether they're going to invoke and honor a legal rule. It's a negotiation, a relationship. Whoops, sorry, I just want to go to the next slide. There we go. Okay, so this relationship is relatively new because the crosswalk itself, a legally designated ribbon of pedestrian priority on the roads, is relatively new. And by some accounts, when people first were introduced to it, they were as confused as the KiwiBot had been. Here's one commentator recalling the day that legally enforceable crosswalks appeared in London in 1934. Lord Trenchard, the head of the Metropolitan Police, was persuaded 2 years ago to authorize the drawing of mystical lines and diagrams at certain points in the streets of the metropolis. With this decoration, certain rules for the conduct of all concerned were issued to the press. Editors publishing the rules don't even profess to not understand them. The introduction of the regime then staged in London a glorious comedy which depicted motorists waiting to see what pedestrians would do and pedestrians wondering whether they really should do what they really should do to solve Lord Trenchard's puzzle. Always good humor and bewilderment, but also a desperate desire to do the right thing. Mr. Stanley Lupino at the Gaiety Theater, this is a famous comedian of the period, came to everyone's rescue. He had one of Lord Trenchard's diagrams drawn up on the stage and then proceeded to get entangled with it. Asked by a fellow philosopher the meaning of the mystery, Mr. Lupino brightly explained, if you are hit by a car when you're crossing this street in this path, and the motor car knocks you down, the police won't blame you. The joke here, of course, is that while these mystical diagrams were painted on the road to keep people safe, signs and symbols can't actually override physical facts in the world, and only an occultist philosopher would think, or sorcerer would think, that they could. But the humor speaks to a real anxiety. What are these signs actually for? What is the law itself actually for? And what can we trust it to do for us? So today I'm going to talk about the early days of the pedestrian crosswalk in Britain and the controversies to which it gave rise. In these controversies, I think we can see a battle playing out between two different ideas of law and what it's supposed to do. On the one hand, law is going to appear in these controversies as a set of adjudications on reasonableness, a corpus of authoritative decisions about what it means to be reasonable within this vexed triangulation of rules, circumstances, and shared expectations. Law's most immediate function in this mode is to apportion fault, be it criminal or tortious, after an accident. Legal theorists argue about the stakes of this larger apportionment. Is it about distributing costs, limiting liability, justifying punishment, deterrence? Probably all of these things, but it's about something else too. As Desmond Manderson has pointed out, it's also about building a paradigm for care. What degree of care do we owe each other in this community? That's the underlying question being asked in these legal decisions about the proper use of the crosswalk. But the crosswalk also speaks to another very different function of law that was especially interesting to people in the 1930s. That is law as a positive mechanism for orchestrating relationships, a tool for producing desired outcomes. This is law as infrastructure, a set of arrangements between people, their practices, and the environment, which is meant to be reproduced across space and time and eventually become taken for granted, or as Susan Lee Starr puts it, become invisible. In its infrastructural mode, law serves as a constructive tool for preventing conflict rather than an analytical tool for resolving it. It wants to take the question of care, what do I owe to whom, how do I act, out of the hands of individuals and inscribe it in the physical world. In the case of the crosswalk, this means using rules and road markings to accomplish what a bridge or pedestrian overpass does in steel and concrete. Law as infrastructure wants to automate a relationship between people and turn it into part of the landscape, something we can trust to behave the same way every time we encounter it and deliver the same results. Now, the crosswalk never really succeeded in automating the relationship between walker and driver because there was, in the years of its infancy, tremendous uncertainty about whether that relationship should be automatic, whether we want perfect predictability on the roads. I'm going to try and reconstruct that debate for you as it played out over crosswalks in 1930s Britain and illuminate its wider political context. This same conversation was happening all over the world in the interwar period as motorizing societies struggled to conceptualize a new relationship to law. In this new relationship, rules featured not so much as norms of virtuous behavior, or really even as instruments of disciplinary authority. Instead, I argue they functioned primarily as codes and passwords, as hieroglyphs to be read rightly or wrongly in a constantly shifting ocean of signs. Gilles Deleuze had a name for this transition, which he dates to the late 20th century. We are passing, he said, from Foucault's society of discipline to something new, a society of control. I think the crosswalk can be read as a harbinger of that shift. Okay, so the idea of segregating pedestrians from wheeled traffic is not new, but nowhere do we see anything like a legal requirement for walkers and pedestrians to stay out of each other's zones until the early 19th century, at least in England. When those regulations do come to London, the pedestrians area, the footpath, is the only one prohibited categorically prohibited to wheeled vehicles. Pedestrians are still free to wander across the King's Highway, which is open to everyone who circulates by foot, horse, or wheel. And for the next half century, there will be no systematic attempt to control or regularize those movements. This remained the case even as the pressure of numbers in urban spaces grew. Now, the rise of the modern automobile in the 1890s is going to change all of this, taking what had been a perennial but ultimately tolerable traffic problem and turning it into a public health crisis. This is the death rate for London from the 1860s to 1896, when the motor vehicle is effectively legalized in Britain, to the explosion of motoring just before World War I, and the even larger rise in car ownership post-war. In 1926, when Britain compiled its first nationwide count of traffic deaths for the year, the number of people killed came in at 4,886. The toll for 1930, just 4 years later, was a stunning 7,305. Pedestrians and cyclists accounted for more than 2/3 of those deaths. So it was in this context of the, quote, Holocaust of the roads, as the papers called it, that in 1927, a few London boroughs began experimenting with curbside signs reading, "Please cross here." They were advisory, not mandatory, and they were aimed at encouraging pedestrians to gather at junctions and cross in groups rather than singly wherever they felt like it. It's as much about increasing predictability for drivers as it is about showing pedestrians where it's safe to cross. But these were just one of a plethora of signs that are popping up all over Britain in this period. Traffic signs before 1930 could be erected by anybody, and they had no force in law. Local councils are experimenting with all kinds of lines and symbols on the roads, and the Ministry of Transport does not as yet have the authority to standardize their shape, form, or sighting. The result of this, quote, prostitution of warnings, as one commentator called it, was that most drivers ignored signs altogether. Those few who did take them seriously, journalists said, were so busy trying to decipher what they meant that they couldn't see and react to what was actually happening on the road. The "Please cross" signs here were signaled out for special condemnation in this regard. Journalists called them, quote, a mockery with the spice of danger, and idle invitations to perform impossible gymnastic feats. One publication called the "Please cross" sign here an invitation to suicide because it was encouraging walkers to cross the road without giving them any real protection from cars. On the other hand, he did acknowledge that pedestrians were being muscled off the public highway, which was, after all, their birthright as British subjects. Can it be, he said, that the civilization we have created is getting beyond our powers of management? We think not, but we must act as well as think. Let us take the notice, "Please cross here," as an invitation to cross the line between confused and clear thought, to get away from haphazard and piecemeal methods to schemes conceived as organic wholes. Now, what did he mean by this, schemes conceived as organic wholes? Well, in the 1930s, thinking on what made for safe traffic is starting to change. For decades, British traffic administrators had been prioritizing flexibility, communication, local knowledge, and responsiveness to real conditions in their policies. They had mostly bought the argument, backed by powerful motor clubs, the way to traffic safety lay in leaving maximum room for the individual road user's personal discretion. But after some fact-finding missions to the United States in the mid-1930s, Ministry of Transport officials were starting to sense that the primary good in traffic control was not responsiveness and flexibility, but rather certainty. Road safety measures, therefore, should be aimed at narrowing the range of possible futures a road user was asked to foresee. The other lesson they took from America was that the main source of uncertainty in a traffic system is diversity, the intermingling of different kinds of road user, each with their own aims, capacities, and expectations. Instead of trying to facilitate communication between these conflicting parties using signs and symbols, Americans preferred to use physical infrastructure to segregate them. Fast traffic from slow, east-west from north-south, and above all, automobiles from everybody else. The most spectacular example of this segregationist instinct was the limited access expressway then emerging in the United States, Italy, and eventually Germany. By 1937, when a high-powered British delegation toured the Autobahn as guests of the Nazis, journalists were calling this select group of nations the Motorway Club and pushing the government to undertake similar infrastructure projects at home, lest Britain be left out of the ranks of modern nations. What's crucial for our story, though, is that motoring advocates saw these infrastructural improvements as an alternative to regulation and especially mandatory signage. Motor-only highways didn't need many rules, the thinking went, because the diversity that made for misunderstanding, misjudgment, and danger would have been eliminated. Everybody would be going the same direction at the same speed. Here was a cure for synovitis. Instead of yield signs and stoplights, we'll have overpasses and traffic circles. Instead of warning notices at blind corners and steep gradients, we'll have smooth and straight national roads. Now, in Britain, control of road construction, though, is still mostly in the hands of local government. Throughout the 1930s, then, we're going to see repeated calls in the motoring press for an authority figure who can cut through the inertia and discoordination of ratepayer democracy and initiate a national roads plan, a traffic dictator. What the country needs is a traffic Mussolini, the chairman of the Royal Automobile Club said in 1933. Someone who will take his courage in both hands and give the country what is good for all. So this is the atmosphere in which a new Minister for Transport, Leslie Horbelisha, assumed office in 1934. He had neither the funds nor the authority to build a British Autobahn, so he did the next best thing. He authorized the construction of a concrete path along Western Avenue in suburban London, separated from the motor traffic by a verge of grass and reserved exclusively for the use of cyclists, an Autobahn in miniature, a cyclobahn. Cyclists, for their part, immediately denounced the scheme as an assault on their right to travel a King's Highway. They saw it as a prelude to banning cyclists from the main road altogether, on the argument that they now had separate but equal tracks of their own. Meanwhile, another segregationist experiment, inspired by examples in the US and also Paris, was proceeding apace. 60 pedestrian crosswalks unveiled in London on June 11th, 1934. Horbelisha had used his powers under a recently strengthened Traffic Act to give pedestrians legal right of way over vehicles on these crossings, which were marked by reflective studs on the pavement and yellow orbs atop 7-foot pillars on either curb. Any motorist who failed to stop and allow the pedestrian to complete her passage across the road would be guilty of an offense and subject to fine. Horbelisha hoped to lay 10,000 such crossing places throughout London. Once they were a regular and accepted part of the traffic infrastructure, he acknowledged privately, the ministry would at last be able to forbid pedestrians from crossing the road at any other point, as was done in Paris, Berlin, and many American cities. He was never able to do this, but the point is that the crosswalk was always meant to go hand in hand with a jaywalking ban. The crosswalk was an assemblage of lines, lights, and laws, but its aspirations were infrastructural. It wanted to function like a bridge, a physical overpass, and eventually replace the situational social negotiation that had heretofore characterized the act of crossing the road. So it was perhaps a sign of trouble to come that Horbelisha himself was almost hit by a car while using the new crosswalk. Equally foreboding was a rash of beacon smashings, which saw some 3,000 of the lamps be wrecked or stolen in their first months of life. But a more telling protest came later in 1937 when a group of motorists called the Society of United Motorists decided to demonstrate their opposition. Decided to demonstrate their opposition to the crosswalk by engaging in what we can only really call civil disobedience. Their method, hyper-compliance. The society declared Crossing Observance Week and called on the nation's drivers to observe these regulations to the letter, slowing to a crawl every time they approached a Belisha crossing. The result, they said, would be traffic chaos. Vehicular circulation in the major cities would be brought to a standstill. So the occasion for this week-long orgy of mass lawfulness was the Court of Appeals' recent decision in Bailey v. Geddes. In that case, the driver was being sued for damages after hitting someone inside a Belisha crossing and defended himself by alleging contributory negligence on the part of the pedestrian. The Court of Appeals rejected this argument, saying that it was logically impossible for a pedestrian to be responsible for an accident inside a marked crossing. Belisha's regulations expressly required drivers to approach those crossings at such a speed as to be able to stop if they needed to. If the driver had followed the law, the court reasoned, the two parties would never have been in the same place at the same time. The United Motorists argued that a finding such as this would theoretically require the driver to go slower and slower until he was fully stopped at every line of studs, just in case a pedestrian should pop out at the last minute. If every driver in the city stopped at every crossing, they said, motor circulation would grind to a halt. Now, did the society really believe this would happen? Probably not. What really upset motorists about the judgment in Bailey's case was the way it appeared to endorse the, quote, mechanical obedience of pedestrians. They feared the court's decision would embolden walkers to step onto a Belisha crossing the same way they stepped onto the bottom stair of a physical overpass, that is, unthinkingly, without wondering whether conditions were right to take that step. Motorists didn't object to this just because it made the roads more dangerous and made them more liable. They thought it symptomatic of a whole new state and engineering-centered approach to road management, which figured good traffic flow as a lattice work of planned starts and stops. That's not actually how traffic works, they said. Road movement is a matter of constant acceleration and deceleration, of incremental adjustments to the social and physical world. Try to contain that ebb and flow within a comprehensive infrastructure of signs and rules, you'll only jam the system cause accidents, and turn the British public into automatons, which, as one commentator said, appears to be the ultimate object of traffic control anyway. The United Motorists intended to demonstrate the folly of this, of a traffic system based on mechanical obedience by indulging in some mechanical obedience of their own, obeying the law as literally as possible. Now, Crossing Observance Week didn't bring British cities to a standstill, but the United Motorists' point was, oh, sorry, these are just some more headlines about how the government is going to turn us into automatons. Less than a week after the point of the United Motorists was well taken by courts, is my point. Less than a year after Bailey v. Geddes, the Court of Appeals clarified its expansive affirmation of pedestrian rights and decided in Chisholm v. London Passenger Transport Board that a pedestrian's right-of-way on the crosswalk did not entitle him to, quote, embarrass the motor traffic by unexpectedly stepping into the street when oncoming traffic was too close to stop. Pedestrians, the court said, must interpret the rule within reason and use their own judgment to decide whether it was the right time to exercise their right-of-way. Law, in Chisholm's case, is not infrastructure. It's not a technology for procedurizing discretionary relationships. It's a post facto recognition of the soft behavioral standards which emerge organically out of specific situations, an adjudication on whether the parties concerned had behaved reasonably. But there was a problem with this approach, and discussion in Chisholm quickly developed into a debate about how close to the crosswalk a car had to be before he was too close to stop. It soon became clear that all the court had really done was displace the question of mechanical obedience, who's allowed to not think about their duty of care, from the pedestrian to the driver. Under Chisholm, it's the driver who gets to stop looking out for his neighbor, gets to go on autopilot and trust the system. The only question is, at what point? 50 feet from the crosswalk, 20, 15? If modern tort law turns on the question of proximity, how far do you have to be from someone before you can stop treating them as your neighbor? Chisholm literalized the metaphor and then inverted it. How close do you have to be to a crosswalk before you can stop thinking of the pedestrian as your neighbor and start thinking of her as nothing more than a malfunctioning component of the system? As Lord Duparc in this quote here points out, this logic effectively made the crosswalk a more dangerous place for pedestrians, since common law duty of care never stops applying to the people in your path on the open road. This is the puzzle of treating law as if it were infrastructure. By trying to automate duty of care, the legislature had ended up circumscribing it. Over the next decade, courts struggled to reconcile the standard in Chisholm with the one set in Geddes, insisting all the while that there was no real contradiction between them. Practically speaking, though, collisions in crosswalks presented judges with a stark choice. Which of the two colliding parties had the right to assume that the other one would follow the rules? Things came to a head in 1949 when the House of Lords heard arguments in Upson v. London Transport Passenger Board. Sorry. In that case, the marked Belisha crossing was also controlled by a four-way traffic light, one facing pedestrians, the other facing the cross traffic. The pedestrian plaintiff stepped out into the crosswalk against her red light, while the bus driver coming towards her was looking only at his green. He struck her. She lived. The Lords ultimately decided that the bus driver had behaved too mechanically, had treated the go signal too literally. Red lights for cars were prohibitive orders, yes, but green lights were different. The green light did not mean the driver must go forward unthinkingly, only that he may go forward cautiously. By contrast, the red light facing the pedestrian did not mean that she may not cross the street, only that she was advised not to. The bus driver, they decided, should have approached the crosswalk assuming the pedestrian might step out behind the taxi and claim her right of way. He had no right to assume that she wouldn't disobey her red light, which was her right. When the master of the rolls objected that these are the quotes just for your reference. When the master of the rolls objected that this would force all drivers to drive in a constant state of fear, as if there were no rules at all, the Lords effectively responded, good. Drivers should approach the crosswalk in fear, as if a pedestrian might step out at any moment. As Duparc had observed more than 10 years before, to treat the crosswalk as anything other than a strict requirement was to undermine the crosswalk altogether. Drivers, therefore, must be ready for their hard legal obligation to fall upon them at any moment. It was the only way to give practical effect to the statute's clear intention, which was to create a corridor of safety on the road for foot passengers. Now, on the face of it, this seems like a classic infrastructural approach to law. The rules are being used as instruments of social policy, not invoked as expressions of transcendent rights and duties. But notice how the Lords have made uncertainty and the fear that comes with it a critical part of the rules mechanism. We typically say that the point of law and of infrastructure is to minimize uncertainty. But in this case, uncertainty, the possibility that a pedestrian might step out onto the crosswalk at any moment, is what secures the policy outcome. This makes the crosswalk an odd form of infrastructure. It's a hard rule aimed at producing specific results, but a rule which doesn't want to become invisible, doesn't want to be taken for granted. Risk and the consciousness of risk is built into its logic. Now, scholars of neoliberalism might recognize this as an early form of responsibilization, but here it is appearing in the high noon of the British welfare state, rather maybe kind of the early beginning of 11 o'clock a.m. in the day of the British welfare state. Compared to other traffic control tools, crosswalks have gotten a fair amount of attention from historians in both the US and Britain, and they're usually presented as an unambivalent power grab by the states, a way of fencing in and enclosing the pedestrian. And this fits really nicely with the sort of Foucaultian interpretation of what traffic control is all about. But as where you're trying to create a disciplined society of enclosed corridors and having people move through those corridors in a procedural sort of way. But as Foucault himself recognized, new forms of domination were emerging in the 20th century. These were societies of control, as Deleuze called them, and they didn't enclose the subject, but rather located her in a radically open environment. She was not fixed within a system of essences, but continuously circulating in a networked field of flows and codes. In this new society, you never fully occupy a definite place in a closed system. Instead, you are perpetually readying yourself for this unstable field to form beneath your feet. So the road traffic order we live in today, I want to suggest, is an artifact of the historical shift from societies of discipline to societies of control. Disciplinary logics like segregation and enclosure are very much present, but so is a deep liberal attachment to the sacred, sort of space of ungovernable flows and shifting relationships. In a society of control, though, these shifting relationships are structured by a grid of extremely technical rules. Traffic rules are not soft paradigms for good social conduct, as they were in the please cross here era, but nor are they simple algorithms to follow blindly. They're codes to be read, recognized, and activated. The crosswalk is a password. If you know what it means and how to activate it at the right time, it will theoretically unlock a situation of safety for you. I think I'll stop there for now, but we can bring this back to AVs if you're interested, or automated vehicles later if you're interested. And yeah, let me know. Thank you so much.
Thank you for a wonderful paper. So our next speaker, Joanna Grisinger, is Associate Professor of Instruction at the Center for Legal Studies at Northwestern, where she teaches courses on constitutional law and history, gender in the law, law and society, and the civil rights movement. She received her JD and PhD in history from the University of Chicago. Her research focuses on the modern administrative state in 20th century US legal and political history. Her first book, The Unwieldy American State, Administrative Politics Since the New Deal, was published by Cambridge in 2012. She's now working on a book on airline regulation as a site for mobilization around issues of race and apartheid, disability, consumer rights, and the environment. And her paper today is The Highs and Lows of Airline Travel, Consumer Rights, Airlines, and the Civil Aeronautics Board. Please take it away.
Thank you. And does the screen share
look? That looks great.
So thank you for, I'm excited to be able to present my research, which I think fits very nicely in terms of what rules can and can't do with Eva's research. So historians talk a lot about continuity and change, and really what better place to see this than in the rich tradition of Americans complaining about air travel. As the jet age dawned in 1958, airlines enticed passengers with the promise of delicious meals, luxurious surroundings, and elite treatment. And in doing so, advertise the luxury and amenities of air travel itself. As you see here, the stateroom, the bunks used to be able to sleep in on planes, the delicious food, the all-steak airline to Florida. Here, Northeast presents, room for your wig box. So all of the amenities that perhaps are no longer available to us. But even then, as now, passengers were disappointed by lost luggage, by delayed and oversold flights, and by the subpar treatment they received. And so they complained. They complained not just to airlines, but to the federal government, demanding that the government use its robust authority to protect them against consumer harms. So I'm putting this story about passenger complaints about airlines in conversation with literature on the third wave consumer movement in the 1960s, where Americans were increasingly outspoken about the ways that businesses cheated and defrauded and endangered their customers and everyone else around them. And so activism around the Civil Aeronautics Board is very much a part of this. So consumers are reaching out to government in this context. In the airline context, they're reaching out to the Civil Aeronautics Board, which was the independent agency with responsibility for keeping the airline industry competitive. Passengers also reached out to their congressional representatives for help, sending them mail as well. And usually, of course, what happened is that the member of Congress would then send the letter to the Civil Aeronautics Board with a note saying, please, respond to my constituent and keep me in the loop about all of this. So a lot of letters that may not have been intended for the Civil Aeronautics Board ended up there anyway. And of course, members of Congress themselves complained to the Civil Aeronautics Board when they were bumped or otherwise inconvenienced. And I think it's useful to think about how much members of Congress fly and how many bad travel experiences they had and their access to power, which led them to complain to the people they regulated about delayed flights they've been bumped from, et cetera. Now, obviously, not everyone who flew wrote and had a grievance complained about it. You would have to know where and how to complain. Complaint scholars, people who've studied complaints, writing in journals like the Journal of Consumer Satisfaction, Dissatisfaction, and Complaining Behavior, note that wealthier and more educated individuals are more likely to identify something as a grievance in the first place and more likely to complain. So when we're talking about airline passengers in this period, we really are talking about a pretty elite group of folks. Fares were pretty high. In 1966, it cost $80 to fly round trip DC to Chicago, which would be about more than $750 today. 1966, it cost $304 to fly Los Angeles to New York round trip, which would be almost $3,000 today. So even with the introduction of half-price youth and military fares, it was really expensive to fly. And so the passengers who are flying are generally either flying on business and their companies are paying for it, so sort of an elite tier of business travelers, or they're flying for leisure, suggesting a significant amount of disposable income. So these are very much the people who would be willing and able to complain. So this paper looks at, which is a chapter of my book, looks at complaints and specifically complaint handling at the Civil Aeronautics Board as a way to see how consumers made demands of this particular federal agency and how well or not it responded. Often these elite passengers are couching their complaints in the language of discrimination, sometimes race or sex discrimination, sometimes rate discrimination in violation of the Federal Aviation Act, and sometimes is more of a status injury, where discrimination is language used to represent the gulf between how people thought they should be treated and how they were actually being treated. And so scholars of relative deprivation theory talk about this, that people are driven to complain about inequities they suffer. And if you think about it, right, the relatively small space of an airline or an airport boarding area means it's pretty easy for parties to compare themselves to others and see what other people are getting. Other people are getting boarding priority. Other people are getting an upgrade, access to an elite lounge, a seat on an overbooked flight that they are not getting. And so couching that as a complaint and as a complaint in the language of discrimination. So I'm coming at this as a historian of bureaucracy, and I'm particularly interested in how a federal agency that wasn't exactly set up for consumer advocacy nonetheless tried to manage all of these complaints. Now, in some ways, the Civil Aeronautics Board is actually pretty well suited to handle complaints, at least ones that said an airline is breaking the law. The Civil Aeronautics Board's other bureaus approved rates and routes and regulated operations. And the Bureau of Enforcement made sure that airlines complied with all of the rules and regulations made by all of the other bureaus at the Civil Aeronautics Board. And they did so in a reactive way. As the Civil Aeronautics Board itself explained in various publications, quote, "We can't pound a beat." So the Bureau of Enforcement mostly followed up on complaints or allegations of wrongdoing, which frequently came from other airlines. Those in the airline industry knew the laws and the regulations inside and out, scrutinized each other's advertising, and had every incentive to report other carriers for violating the law, for illegal acts that affected their own financial position, right? We're not allowed to do that. They're trying to get away with something. So a reactive approach to enforcement, one that relied on other airlines to basically turn each other in, was likely to catch a lot of behavior, like when airlines flew routes they weren't authorized to fly, or airlines flew passengers for free when they weren't allowed to do that, or when airlines falsely advertising turboprop planes as jet planes in their ads, or advertising flights on a DC-7R plane, which was not a plane that existed, or advertising that they had the lowest rates when everybody charged the same rates. So a lot of these reports would come in from airlines complaining about other airlines, and the Civil Aeronautics Board's Bureau of Enforcement would try informal negotiation first. As their lawyers explained, they preferred a friendly phone call as a method of bringing an airline into compliance, basically telling them to knock it off. If the airline didn't stop its behavior as a result of the CAB attention, the Bureau of Enforcement had to decide whether it was worth it to dedicate resources to launch a full formal enforcement action. It meant the Bureau of Enforcement often declined to move forward if the violations didn't seem like a priority for its limited resources, and one-off passenger complaints often fell into this category. For example, in 1958, Executive Edith Ryan complained to the Civil Aeronautics Board that United Airlines refused to let her fly the evening all-male, all-first-class executive flight between Chicago and New York that was intended as a luxurious respite for tired businessmen. This seemed to her and to many like a violation of the Federal Aviation Act's pretty clear non-discrimination language. United actually sent 2 men to her office to convince her that she wouldn't like the flight anyway. She remained unconvinced. The Civil Aeronautics Board did not take formal action on this. And even a decade later, even though CAB staffers recognized, are now writing in memos that this is clearly illegal to simply bar women from this flight, the chairman of the CAB thought that formal action was not compelling, given, as he said, any inconvenience to women travelers appears to be nominal. There were, after all, a lot of other flights that women could take. The National Organization for Women gets involved in the late 1960s about this, pushes for change, and sort of significant pressure and embarrassment leads to 71, the United phasing out its executive flights. Sometimes the airlines would take action. Sometimes the Civil Aeronautics Board would take action if the complaints it was receiving seemed like a broader problem that affected more people. For example, in 1965, businessman Herbert Goldberger complained about being turned away from American Airlines Admirals Club during a stopover in Detroit. Now, in the 1960s, clubs like the Admirals Club, Pan Am's Clipper Club, TWA's Ambassadors Club were all membership-only clubs where you could only join if you were invited by the airlines. At American, for example, applications would be decided on by an admiralty board, and new members would be ceremonially commissioned by staff as admirals. And you would get, joining one of these clubs, you would get a formal certificate, a plaque that you could hang and frame at your home, many of which have now ended up on eBay, which is where these photos are from. Those invited to join American Airlines Admirals Club included not just frequent travelers, but high-level executives, diplomats, members of Congress, state and city officials, judges would be selected to join. And then they would get access to lounges, to a special reservation line. And this didn't seem quite right to Herbert Goldberger, the businessman who complained. It also didn't seem quite right to the Civil Aeronautics Board, which hadn't taken action on its own, although, of course, none of this is a secret. But upon receiving this complaint, looked into this as a violation of fair discrimination rules. Airlines couldn't discriminate on fares, that is, charge different people different amounts, but such special treatment did mean that certain passengers were getting more services for the same amount of money, and that didn't seem quite right. It took 8 years of Civil Aeronautics Board pressure before all airlines agreed to open club membership to all applicants. As businessman Herbert Goldberger remarked, quote, in the annals of man's inhumanity to man, this ranks at the bottom of the ladder. But as he said, it's the principle of the thing. Now, this is mostly reactive enforcement, as I said, but if there were enough complaints coming in about an issue, the Civil Aeronautics Board would consider making a rule. And airline bumping and overbooking is an example. There were lots and lots of passenger complaints about being bumped from a flight when an airline overbooked or oversold the flight. Members of Congress, who, as I said, flew a lot, are particularly attentive to the problem. And when they got bumped, they would write to the airline, they would write to the Civil Aeronautics Board, and they'd make speeches on the floor of Congress, sometimes in unrelated hearings, at which point people would stop and say, what does this have to do with anything we're talking about? But they were angry. Now, it wasn't actually against the rules for airlines to overbook flights and to bump passengers. It wasn't necessarily even anti-consumer. Passengers hated being bumped from overbooked flights, but they loved not showing up for flights. So there was sort of a problem there. If they made a reservation on the phone, and now remember, we're talking about a period where you call the airline, you could make a reservation, but you wouldn't actually pay for your ticket until you either went to your travel agency or you went to the airport to actually take your flight. So there's a significant gap there between the number of reservations an airline might take and the number of tickets sold. So there's some distinction here between overbooking and overselling a flight. But generally, passengers enjoyed the opportunity to make reservations, not show up for their reservations, or make a lot of reservations. There was no risk for the passenger, right? Again, they haven't paid any money. So secretaries would often reserve spaces for their bosses on multiple flights on the 3 o'clock, 4 o'clock, 5 o'clock, 6 o'clock shuttle, and then so that their boss could simply show up for whichever flight was most convenient. Holiday travelers would make multiple reservations and decide on their travel when the time came. This meant, of course, it was really hard for the airlines to figure out how many seats they would fill. They would overbook flights, and then on certain occasions, the math would be wrong and people would be bumped from flights. The Civil Aeronautics Board engaged in a tremendous amount of rulemaking in the 1960s and 1970s to figure out who to penalize. Do you penalize the passenger? Do you penalize the airline? Sort of who's to blame and who should bear the cost there and how to manage. And it took a couple of decades before they settle on more or less what we have now, which is paying volunteers to give up seats. Now, as of the late 1960s, the Civil Aeronautics Board seemed to think it was doing a pretty good job protecting customers. It looked into allegations of lawbreaking as they came in. It tried to address other areas of discontent, things like bumping and oversales and unfair treatment through individual enforcement actions and through broader rulemaking. And it seemed like this was a decent way of balancing the needs of individual passengers and air transportation as a whole. But many were not happy with the CAB's approach to protecting passengers. For example, the U.S. Commission on Civil Rights took the CAB to task for a complaint-based model that they found really unlikely to ascertain whether racial discrimination was happening on airplanes. The CAB pointed to the lack of complaints it got about racial discrimination, something like 14 complaints about racial discrimination as of January 1970, which was really a drop in the bucket, they said, given the thousands of complaints they received about overbooking and baggage loss and late flights, et cetera. But as the Commission on Civil Rights pointed out, a complaint-based model is problematic when passengers who are discriminated against are unlikely to know where or how to complain. And so without signs about where to complain, about knowing that there is a thing called the Civil Aeronautics Board, it's unclear that a complaint-based model is actually capturing all the grievances. At the same time, though, the CAB is pointing out that the number of complaints it's receiving are going up dramatically. And they're probably even going up slightly more dramatically than this. The CAB changes its reporting sort of in the middle here in ways that focus on simply consumer complaints. So the earlier years, 66, 67, are capturing complaints from airlines as well about other airlines. But in fiscal year 1966, there are about 1,600 complaints coming into the Civil Aeronautics Board, going up to 4 years later, more than 4,400 complaints. So the numbers are sort of doubling and doubling. And again, so the CAB is responding to the Commission on Civil Rights, saying, everybody else, lots of other people are complaining about lots of other things. There seems to be some knowledge among Americans, at least, where to complain to. In 1970, Ralph Nader's Raiders get involved in the space of airline regulation as well, creating the Aviation Consumer Action Project to push the CAB to also be more proactive, as they say, to protect consumers before complaints are necessary. And the Aviation Consumer Action Project, again, led by Nader's deputies, spends a lot of time using this complaint process to bring matters it's interested in to CAB attention, going to court if the CAB is taking too long in responding to its complaints, and demanding rulemaking whenever it can. Now, in the early 1970s, the CAB establishes a specific Office of Consumer Affairs focused specifically on passenger concerns that aren't legal violations. Recall that what I've talked about already in terms of, all female or all male flights, discrimination in passenger clubs would appear to be actual violations of the Federal Aviation Act, whereas overbooking and such are things that aren't a violation, but people are mad about and angry about, and should the CAB do anything? And so the volume of complaints about things like that aren't legal complaints, but are often couched in the language of discrimination or unfairness, nonetheless become so voluminous, the CAB creates a specific office for this, to handle all of this business. So it's a dedicated place for consumers to direct their complaints about services, overbooking, reservations, and other matters, again, many of which reflect bad service, but aren't really violating any rules or regulations. The office engages in outreach, publishing pamphlets like the Air Travelers Fly Rights that put regulations into plain language and end with how to file a complaint. You can see the topics addressed here on the image: fares, denied boarding compensation, delays, refunds, baggage, etc. And the White House studies of complaint handling in the mid-1970s marked that the CAB's performance excellent among all of the other agencies, that it's sort of doing among the best jobs that the agencies are doing in handling consumer complaints. Now, it's probably not surprising that issuing a pamphlet telling people how to complain, the numbers of complaints received by the CAB goes up dramatically. They immediately get a lot of new complaints covering a host of matters, including lots more complaints about overbooking, lost luggage, the fact that airplane bathrooms don't have seat belts, the fact that TWA isn't serving hot dogs, the sexism of National Airlines Fly Me campaign. Again, people are complaining in the streets. They're also complaining to the Civil Aeronautics Board. Continental has a similar slogan, "We'll move our tail for you." A significant number of complaints come in about that as well. The CAB chairman noted that a temporary upsurge of complaints was to be expected now that Americans had more information about where to complain, but this upsurge never really stopped. The CAB received more than 7,500 complaints in 1971. By 1974, the number had doubled to more than 15,000 complaints a year. But the Civil Aeronautics Board was never really set up as a consumer bureau. It's set up to regulate the airlines. And a lot of what the complaints that the CAB is receiving can't actually be settled by the CAB in the passenger's favor. So one of the things, the CAB can sort of take the complaints and hear the complaints and send the complaints to the airlines and ask them to address it, but that's about all they can do. The CAB has no provision to ensure that passengers get damages. The passengers who've been injured in some fashion get damages. That's for the courts to do. The CAB's only remedial authority was to issue a cease and desist order, or later on a civil fine that went to the government, but not to the passenger. And there were instances of passengers taking to the court to redress their grievances. In a notorious case of racial discrimination in the 1950s, singer Ella Fitzgerald, flying first class from San Francisco to Australia on Pan Am, was prevented from reboarding the flight after a stop in Honolulu. Fitzgerald successfully sued for damages after the court finds a private right of action in statutory non-discrimination language. But in practice, it's difficult to go to court, and it's not a great option. Practically, it's not a great option for routine grievances. There is some litigation over overbooking, mostly brought by lawyers representing themselves and for whom the costs of filing a lawsuit are pretty small. And generally, unless you can convince a court that punitive damages should be awarded, it's not really worth it. For example, one California lawyer sued TWA for bumping him in favor of a first-class passenger when there weren't enough seats on the flight. The court was sufficiently shocked by TWA's behavior to award punitive damages, but the compensatory damages in that case were only $1.54 for the cost of the long-distance phone call to his wife. Ralph Nader famously sues Allegheny Airlines for $50,000 for bumping him. He doesn't collect, but he gets some judicial victories along the way that leave him on the moral high ground, at least. In 1981, Illinois Supreme Court Justice Thomas Kloczynski and his wife were sued following an episode where they were bumped off a flight from Chicago to Miami en route to visit a millionaire friend and celebrate the birth of a horse. Here, a jury awarded them each $100,000 in punitive damage, which courts would later reduce significantly, even though, as they pointed out, their weekend had been ruined. But judicial solutions were often, again, not where people might go if they'd been bumped, if their flight was late, et cetera, given the costs and impracticality of all of that. Sometimes the Civil Aeronautics Board sending a complaint to an airline under cover of a CAB letter, sort of the attention might be enough to prompt an airline to refund the money. And the CAB described using moral suasion to convince airlines to compensate its passengers. By 1973, the CAB would brag that carriers had paid more than $500,000 to refund or compensate passengers and shippers, mostly in small cash payments, so indicating they're going to a lot of different people. And airlines start building up their own consumer mechanisms because they, of course, are also getting this wave of complaints. But if the airline didn't do anything, the CAB had no power to make the complaining passenger whole. So it was frustrating for consumers to write and be told by the CAB that there was nothing to be done or that they should go to court. As Sarah Ahmed, who writes on complaints, describes, in some ways the CAB here is offering a process instead of a solution, a place to complain and a process for addressing complaints, but not really a solution to any of those complaints. And so it's worth thinking about this gulf between what passengers expected would happen on the plane and what really happened, and then what they expect is going to happen if they complain to the Civil Aeronautics Board or the airline and what actually happens, and sort of a double dissatisfaction in that case. And so it was probably not great for the Civil Aeronautics Board's political fortunes for consumers to experience this sort of often a letdown when they were in contact with the Civil Aeronautics Board. Did this turn away Americans from the CAB, leading to deregulation? That's way too simple an explanation. I'll just say it didn't really create a group of people willing to fight for a Civil Aeronautics Board against deregulatory pressures. And with deregulation, the CAB goes out of business, basically January 1, 1985. A significant amount of regulatory authority that had been created in the CAB and the sort of potential for more action there that could have been deployed to protect customers basically evaporated with the other regulatory functions of the Civil Aeronautics Board. And I will stop there.
All right, well, thanks very much. So we have just about half an hour for discussion. If anybody wants to raise a question, I might just start with a very brief question to Eva. So I noticed in some of the material on your PowerPoint, one of the things that the crosswalk, or that all users we're supposed to notice. Sorry, I hope you can't hear my phone making this very annoying sound. Yeah. So one of the judges was saying that both the crosswalk users and the drivers were really supposed to draw on experience, knowledge, and common sense, sort of eliciting the idea that reasonableness is really the underlying layover that the crosswalk imports with it. So this just reminds me of the detail that the reasonable person, as personified by courts, is sometimes characterized as the man on the Clapham omnibus. So what I find interesting about your examples is that it sort of literalizes the idea of reasonableness or the reasonable person as activated precisely by mobility, circulation. And I was wondering if you might just say a bit about that. The idea that somehow traffic or walking or movement seems to be the star case of the activation of reasonableness as a standard.
Absolutely. I've been thinking about the man on the Clapham omnibus for a long time because he's very much not a driver. By definition, like that's the interesting thing. He's not the one making these decisions. So I haven't figured out exactly how I want to play with the what happens when the man on the Clapham omnibus gets behind the wheel, because there's also there's a story about class there as well, about upward mobility that's really interesting, and I'd love to play with. Haven't managed to yet, but I'd love to. But all I would say to you, to your question, is that this is one of the things I love about this story, is that this has been true from the beginning of negligence law. I've been going way deeper into the 17th and 18th century than I really should, and looking at the emergence of this reasonable person, and they're so often attached to traffic cases, precisely because what everyone seems to accept is that physical proximity on the open ground, the undifferentiated space of the highway, must create some kind of obligation. And we'll see this as the duty of care is becoming articulated in the middle of the 19th century, is that people keep talking about, oh, you know, guy with a haystack, how is this like or unlike two carts approaching each other on the street? Or they'll also use ships as well. So yeah, no, the idea of mobility, and specifically mobility in this space of equality, which is the road, is kind of like the paradigmatic case for the reasonable person, all the way from the 18th century straight on to to this period. Yeah.
Yeah, that's wonderful. Thanks. Others?
Simon, I have a question, but I can't find the hand raise. So,
Oh, go ahead, please.
okay. I can't tell if anyone else has your hands up. So hopefully I didn't just cut everybody. So fantastic papers to both of you. Thank you so much. I'm gonna follow up Simon's question with another question for Eva. And maybe this is really just a clarification for me. It came up as you were thinking, sketching initially, that really interesting and I think helpful distinction between law as adjudicating reasonableness versus law as infrastructure. And initially, as you were setting it out, I think the last thing you said in the first camp, law as resolving a conflict, kind of like law as its classic sense, was also used to build a paradigm of care. And I think you were like connecting that to the first definition of instance of law. And it seemed to me that it really blended over into the one that you then moved into, the law as infrastructure, law as preventing conflict, because of setting out and really trying to shape behavior so that people don't need to actually use the, resort to law in the first place. So it seemed like that idea, the language of care, blurred over and maybe even connected the two instances, so that if, and I wondered if this is correct, maybe I just misheard you, or if this is a useful way of thinking about it, that the language of care could be both the standard that people use to resolve the conflict, but also the idea that the law is seeking to instill in people like this duty so that it is shaping behavior as well.
Yeah, that's a super, super helpful point. I think the turn when we move from care as a soft standard to care as a form of something else, a form of preventing, of infrastructure, as I keep trying to say, or as I keep trying to push. I'm not sure if it works, but the difference to me is who is making decisions about how to honor the care. And so, like, for instance, and there's this whole other side of the story, which is bound up in debates in the 1930s, or all through the 20s and 30s, about whether or not simply following the rules set by the state is enough to satisfy your duty of care. And so there's a famous case in 1917 where the statute says you have to have one light on your car, but the judges find that this person was being unreasonable because he should know that in this locality, in this area, it's probably more reasonable to have two. Like two headlights are what would satisfy that duty of care. So I think you're totally right. It's the bridge concept that I'm going to use that as a bridge between the two concepts, but the way care is decided upon in the infrastructural mode is through following rules, I suppose. Whereas when it's in this sort of adjudication mode or this sort of paradigmatic mode, it's about making these kind of situational judgments about the circumstances. And so it displaces who is responsible for deciding what care looks like, I guess. So, and again, the idea of infrastructure as trying to automate duty of care and maybe like remove all the uncertainty that goes with an individual making those decisions is kind of what I want to hammer home. But I love that. That's a great way to bridge the two concepts. So thank you. Yeah.
Absolutely. Thank you for a fantastic paper.
Thank you.
Yeah, I'm not sure what happened to the raise hand function, but if you want to ask a question, please just put yourself on video. So Joanna, I guess I had a question about the relationship, I guess, the question of remedies that you address. So we have this complaints board. It seems to be designed with the knowledge that they'll have little efficacy in actually imposing sanctions. So, on one view, there's a design flaw because they're not equipped with remedial powers. On another view, maybe there's a reason why it was designed that way that's consistent with the overall purpose, but obviously creating the opportunity seems bound to lead to dissatisfaction for consumers. So I was wondering if you could say more about that aspect. I mean, it seems like you're creating a regime in which there's going to be an expectation of enforcement and the knowledge that the enforcement powers are weak at best.
Yes, I think there really is this, I think, so stepping back and looking at most of the federal regulatory agencies in this period, like as far as I can tell, there is this wave of consumer complaints, right? Had the sense that not only are, are there consumer issues, but the federal government should be stepping in, right? In 1962, John Kennedy announces a Bill of Rights for Consumers. There's a sense that the federal government should be taking a strong stand. And so what I find interesting about the Civil Aeronautics Board is an agency that, again, a lot of people didn't know existed. A lot of people, when I talk about my research, don't know existed, and was, very much set up to maintain a competitive air transportation industry and is not set up really for consumer complaints, but consumers sort of find their way there in a lot of ways. And so unlike other agencies that might have not had any complaint-based mechanism, the CAB sort of has a little bit of one already. They have something that looks like that already. So they're, able to take these things in. But the demands, and of course, the Nader folks are going to every single agency and demanding that that every single agency, do more for consumers. And so, I think you sort of have this odd, like, oh, we actually have something like this, and we're getting the complaint, so we'll put people in charge of it, and we'll give them a little more power, and we'll give them the ability to intervene in cases before the board, and we'll do within our statute what we can. But there's not necessarily any successful push to imbue the Civil Aeronautics Board with more authority to do anything about this. And again, the courts are right there. And that is, it's just a simply very traditional distribution of resources. And if you're a lawyer, that makes perfect sense. But if you're someone complaining about a flight, that this sense of like, no, we are to handle, this part of things. And if you want individual grievances addressed, you go to court and you file a lawsuit for your late flight. That doesn't, seem like a super appealing option. Again, a lot of lawyers are flying, so there is more litigation than you maybe might expect because they're just filing lawsuits when they have a bad flight. But that is not, I think it's what I'm trying to get at in this chapter, and it's still a pretty early draft, is this sort of disconnect between what people think the government should be doing and in a lot of ways, the way the government just sort of simply works. I definitely don't think the Civil Aeronautics Board is doing anything wrong here, so much as this is just sort of the way things work, and consumer expectations as to what might happen are sort of out of line. And while I think in the airline context, it makes sense that the airlines are, touting all of these luxuries. And then, of course, things sort of inevitably go wrong in airline travel and people get dissatisfied. They have these expectations of what the government can do for them that aren't in some ways practical. They're unlikely, but trying to manage that is certainly not something that the Civil Aeronautics Board is set up to be doing in the first place, while they're trying to keep all of the airlines from just going bankrupt in the 1970s from, you know, terrible economic choices they've made. And so I think just trying to get at the sense of the disconnect, I think, is what I'm interested in and I'm trying to figure out.
Yeah, in so many ways, both these papers are about changing expectations of the state and changing expectations about what government is supposed to do for you, and particularly expectations by elites. You know, I think it's interesting. I mean, how similar these admiralty clubs sound to the motoring clubs who are driving all this litigation in my story. You know, so I mean, this idea of empowered. You know, if I may, I was going to ask you a question. Why was the CAB worried they weren't getting enough complaints about racial discrimination? Like, why would they want more complaints?
Well, no, I don't think they are. They're not worried about it. The U.S. Commission on Civil Rights is very
Oh,
worried.
I see. I misunderstood. Yeah. Yeah.
Of the idea that it's a problem. And I think with the idea that, you know, everybody else who may not know we exist somehow finds their way here and complains that the airline lost their luggage, and we're getting thousands of complaints about that and thousands of complaints about late flights. If we only got 14 complaints about racial discrimination, most of which are either not in our jurisdiction or, after a little investigation, don't seem to have any merit, then it can't be that big a deal. Seems to be the idea, as opposed to, okay, well, let's think about who might complain and what the how things might be different, and also maybe some of those complaints are more serious, et cetera. And in the most bureaucratic thing I've seen, which is saying a lot, there is the U.S. Commission on Civil Rights is complaining about compliance under Title VI of the Civil Rights Act by the CAB, that they haven't taken formal steps to comply, to make their own rules, to report, you know, what they're doing in terms of making sure that airlines are not discriminating when they're receiving federal funds. And their evidence is, we have a file on the CAB and that file folder is empty. It's like the most bureaucratic evidence that they're not doing anything about it. But the CAB thinks it's going to be actually too much of a burden on airlines to put up posters saying, here's where you complain if there is an issue. And the Commission on Civil Rights is saying you should have, you know, airline staffers, when they're flying themselves, they should be keeping an eye out. You should have posters. There should be the kinds of compliance posters that are now, you know, pretty common in various places. Again, these are not that aggressive moves, and CB is like, oh, that's way more, oh, that would be too aggressive. And so there's definitely some, and this is just one of the dynamics I've been tracing throughout the book, is less that the CAB is sort of, you know, hostile to civil rights so much as they just tend, you know, the formal action suggests sort of like just not within their remit, right? That's not a thing that they need to be paying positive attention to. Their job is to regulate the airlines. And when people come in and say, well, that also means regulating like the noise airlines make or airlines' racial policies, there's definitely some formal hesitation about whether that's their job. And whether they're going to get attacked by Congress if they do that.
Yes, Emma, please.
I have a question for Eva. I was just wondering if you could say a little bit more about the distinction in your work between discipline and control.
Thank you. Yeah, I cut that bit short because I'm also I'm anxious about it because I'm not a theorist and I don't want to be like necessarily making any interventions in Foucault studies or Deleuze or anything like that. But I was very excited when I came across that essay of Deleuze's, which I can send you if you're interested, on societies of control, in the distinction that he draws between a world that is structured around enclosures in the 19th century, where you basically move from family to schoolroom to barracks to factory, and each of these enclosures has a set of rules that you follow that because of, and your role within those structures is very fixed, right? And this is the kind of collectivist society that kind of like is coming into being in the or sort of achieving its zenith, I suppose, in the middle of the 20th century at this point. What Deleuze then starts talking about is the new, what he's seeing as a new form of governmentality, basically, a new form of regulating how people behave. which is less about fixing them within situated structures. Like, again, you are a student, these are your rules, this is how you behave when you're in the space of the classroom, and is more about, I'm going to screw up the actual presentation of it. I mean, basically what he's referring to is the phenomenon of neoliberalism as experienced in the global north. The idea that it's about how you adapt and are constantly retraining yourself for the flows of the market, for the ebb and flows of the market to come and change your role, to come and require you to be different and react again in a sort of non-standardized, non-role specific way. So he was referring to, I think, specifically to the kind of dislocations and instabilities of the neoliberal order as was emerging at that time in the 80s and 90s. But for me, what's interesting is the way is how similar what he is saying. Is the similarity between the world he's describing and the world that a traffic rule like the crosswalk or the yield sign expects you to inhabit. To me, it was always really, I know when I was learning how to drive, I found it so frustrating because I was like, there's a sign here saying stop, but I'm the one who has to decide when it's time to stop stopping. And then if I make that decision wrong, I'm going to kill somebody. I was a very anxious driver, obviously. And so the sense of uncertainty about not just what rules I should follow, but when and how they should apply. Effectively putting, I mean, I tried this thought out before as well. The idea that basically being in traffic kind of among traffic rules requires like pretty much everybody to be constantly adjudicating hard cases in the legal theory sense of the term, constantly wondering, okay, but is it the right time for this rule to apply? Does it apply in this case? You know, that sort of stuff. And then the displacement of that onto individual movers on the street is what interests me. So that's what I'm trying to go to. It's a still really unformed thought, and I'm not sure how far I want to go with it either. But yeah, I was trotting it out here to see what kind of reaction it would get.
Thanks, that's great.
Well, thanks very much. It seems like there aren't more questions. So I'll just say thanks to both of you for terrific presentations, and we really appreciate your doing this.
Thanks so much for the opportunity. It was awesome.
Thank you all for coming.
Thank you. Yeah.